Good afternoon. This is Heidi Meyers, immigration attorney. Today we're going to talk about removal proceedings in immigration court. How do you get placed in removal proceedings, also known as deportation proceedings? The government has to serve you with a notice to appear. The notice to appear is the charging document for immigration court. On the top, it will say whether there's boxes that are checked off or not checked. First is whether or not you're an arriving alien. An arriving alien is a foreign national who is not considered to have been admitted to the United States, or who has not been considered to have entered the United States. So the arriving alien basically is a legal fiction. So the legal fiction is that you're standing at the port of entry to the US and you're knocking on the door and asking to come in, and you have not been allowed in. So even though you're physically here, your body is in the United States, legally you're considered not to have entered, not to have been admitted to the United States. Now, the other category that you might be charged under is that you have been admitted to the United States, but you are deportable or removable for certain reasons. So an example of that would be where you have an H-1B visa to work for an employer. You are inspected by CBP and you are admitted to the United States at JFK Airport. You go to work for your employer, but then you're laid off and you can't find a new job and you cannot transfer your H-1B. So then you were admitted to the United States, but you are removable or deportable because you have fallen out of status. So that's another example. The third option that they might charge you under is that you entered without being admitted, meaning you just sort of ran across the border, say you went from Mexico across the Rio Grande River in the middle of the summer when it's only, when there isn't too much water, and you came into Texas, so you entered without being admitted and you're physically present here. So that's the other option. Then the notice to appear will list certain very basic facts that they're alleging. They will say you are a native and citizen of whatever country, maybe Pakistan, India, Mexico, Egypt, wherever it is they believe you're from, and that either you arrived in the US on such and such a date, or you were paroled, or you were inspected and admitted. So they'll generally have the date that you entered or tried to enter. And then they'll have what they think makes you deportable, like I said, just very basic facts. Not anything long-winded, not anything descriptive, just extremely basic. And then it will list the grounds of inadmissibility or deportability against you. So the first time you appear in immigration court, it's at what is called a master calendar proceeding. A master calendar is where the judge has scheduled maybe 40 other people at the same time as you. So you want to get there early before everybody else, and you don't spend too much time with the judge. The master calendar proceedings are procedural. They're not going to go into the substance of whatever claims you have or whatever relief from removal you have. They're not going to go into your whole long story. Okay, so basically the first time you go is to respond to the charges in the notice to appear. Now, in immigration court, you do not have all the rights that criminal defendants have in criminal court, which is one of the big problems, basically, that we have with immigration court, is that you don't have as many rights. However, you do have due process rights under the Fifth Amendment to the US Constitution. So you have a right to fundamental fairness and due process under the Fifth Amendment. So what does this mean? This means that you have the right to an attorney, but at your own expense. So if you have money, you can go get yourself a lawyer. to represent you in immigration court, hopefully zealously. So, but if you don't have money and you can't find a lawyer, the government does not have the obligation to provide you with a lawyer for free. So that's the difference. Another aspect of due process is that the immigration judge is supposed to be an impartial adjudicator. The immigration judge is not supposed to be biased against you. If the immigration judge is biased against you, that can be a due process violation. Another right you have is to competent translation. So, for example, if you don't speak English, or if you do speak English, but your English is not fluent, you really need an interpreter, you have the right to a competent interpreter. That means the immigration court has to, well, they have a lot of their own interpreters, or they call an interpreter on the phone. So if the interpreter is not translating word for word, if the interpreter is making all kinds of mistakes, then that is also a due process violation. Now, if you do have an attorney, the attorney is supposed to represent you properly. And another aspect of due process is if there is ineffective assistance of counsel. That means the attorney is so negligent or so lousy that your case is prejudiced, then that also can violate your due process rights. Another due process right you have is that the immigration judge is obligated to inform you, if you haven't already applied for relief from removal, if you are eligible for certain relief from removal, if you are eligible for certain waivers or some other immigration application or adjustment, the immigration judge is obligated to inform you of your eligibility for relief from removal so that you will have the opportunity to make the application. So these are just some aspects of your due process rights in removal proceedings. Another aspect of due process is the right to confront the witnesses against you. This is in the regulations. It's also considered part of the Fifth Amendment right to due process. Now, immigration courts are not Article III courts. That means they are not independent federal courts. The immigration court is under the U.S. Department of Justice. So the immigration courts are a sub-agency called the Executive Office for Immigration Review, which is part of the U.S. Department of Justice, which means that the ultimate boss of the immigration judges is the U.S. Attorney General, meaning the immigration courts are subject to a lot of political pressure, unfortunately. Now, so in immigration court, you're going to have a chance to challenge the charges in the notice to appear. And then later on, if the judge finds you inadmissible or removable, you are allowed the opportunity to apply for whatever relief from removal that you're eligible for, such as maybe asylum, withholding of removal, withholding under the Convention Against Torture, adjustment of status to permanent residency, and then there are also various waivers that you might be eligible for. So later on, you will have an individual hearing. So an individual hearing is where you testify, you bring all your witnesses testify, and the judge and the lawyer for immigration, the prosecutor. The prosecutor for immigration is usually called the trial attorney. So your attorney will ask you questions, which is called the direct examination, and then the immigration judge might jump in and ask you questions also. And the ICE trial attorney, which is ICE's district counsel, will also cross-examine you and try to make you look like you're lying or you're making inconsistent statements or, undermine whatever your claim is. All right, so that's the basic procedure in immigration court. Now, if your case is granted and the ICE trial attorney does not appeal, that's wonderful, that's great. If, however, you lose your case in immigration court, there are two levels of appeal. The first level of appeal is to the Board of Immigration Appeals. You have 30 days once the immigration judge issues their order to file a notice of appeal with the Board of Immigration Appeals. Later on, the BIA will send a briefing schedule and also a copy of the transcript of the hearing, and you'll have the opportunity to present a full brief. Now, similar to immigration court, the BIA, the Board of Immigration Appeals, is also part of the U.S. Department of Justice, which means their ultimate boss is the U.S. Attorney General, which means that the BIA is also subject to a lot of political pressure, especially in recent years. So this has made it very, very difficult for immigrants to get a fair hearing and a fair appeal in the current conditions. So that's the one level of appeal, is to the Board of Immigration Appeals. Then there's a second level of appeal to the Federal Court of Appeals, which is, those are the Article III courts, the independent judiciary established by the U.S. Constitution. And which circuit you're in for the Federal Court of Appeals depends upon where the immigration court proceedings were held. So for example, if your immigration court case is in New York, New York at 26 Federal Plaza, the Federal Court of Appeals would be the Second Circuit here in New York. If your case was in the Newark, New Jersey immigration court, then it would be the Third Circuit. So it depends on the location. If your case was in Houston, Texas immigration court, it would be the Fifth Circuit, and so on and so forth. So you have two levels of appeal after the trial court. The trial court, like I said, is the immigration court. Now, it is possible, although not very likely, that you can also appeal to the U.S. Supreme Court if your case is denied at the level of the Circuit Court of Appeals. Very, very few cases are appealed to the Supreme Court, and even if you try to appeal, you might not get a writ of certiorari because the Supreme Court handles very, very few cases. All right, so those are the basics of immigration court proceedings. That's sort of the basic, just to give you a very basic idea. It gets much more detailed and much, much more complicated. I just wanted to give you a little overview. All right, so this is Heidi Meyers, immigration attorney. And if you have any general questions about immigration law, I'm happy to do a video on them. I'm at 11 Broadway, Suite 925, New York, New York, 10004. My number is 212-791-4007 or 646-508-5225. That's 646-508-5225. And my email is HeidiMeyersLaw@gmail.com. All right, so thank you very much. And don't forget to like my video and subscribe to my channel. All right, have a good afternoon. Bye-bye.